Next case, State of Kansas versus Sydney Taylor Leslie, 25 CR 250. Good afternoon, Miss Leslie. Miss Leslie, you're charged by way of information on or about May 21, 2025 in Butler County, Kansas, with interference with law enforcement, a Class A non-person misdemeanor. Count 2, same date and location, no proof of insurance, a Class B non-person misdemeanor. Same date and location. Count 3, no driver's license in possession, an unclassified non-person misdemeanor. Though, then count 4, same date and location, failure to register vehicle, an unclassified non-person misdemeanor. And Miss Leslie, do you understand the charges pending against you?
I comprehend the alleged charges against me.
Thank you, Miss Leslie. Miss Leslie, you do have the right to counsel. If you cannot afford an attorney.
Excuse me. I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights, which I explicitly refuse to waive pursuant to KSA subsection 60-212 in the doctrine of special appearance recognized in Kansas jurisprudence.
Okay. You do have the right to counsel. If you cannot afford an attorney, one would be appointed to represent you. And Miss Leslie, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-308. Let the record reflect that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden-shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 2004, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the four corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. The threshold matter of jurisdiction must be adjudicated prior to any other proceedings. As articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court, jurisdiction is the fundamental prerequisite to all jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
Okay, and the court finds that Miss Leslie is appearing as a sovereign citizen before the court, and the court once again.
I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds and disqualification.
Court overrules the motion for dismissal of the case. Court overrules dismissal of the prejudice case. And the court will find that Miss Leslie, that the court does find it has jurisdiction to proceed, and subsequently the court sets your next appearance date.
You called me a sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias.
No prejudice or bias is asserted as to yourself. However, the court, as opposed to trying to write down docket notes to that effect, is just recognizing what you are advising the court, that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond. $3,000 cash bond has been made. Court does accept the same, and the court does schedule this matter next before Judge Webster on Monday, August 11, 2025 at 9 a.m. Monday, August 11, 2025, 9 a.m. before Judge Webster. Once again, Monday, August 11, 2025, 9 a.m. before Judge Webster. You do need to participate by Zoom process at that point. Subsequently, the court finds that Miss Leslie has not requested court-appointed counsel. Court does not appoint counsel at this point. The court does find that she has posted bond in the amount of $3,000 cash, $3,000 cash bond, and the court has scheduled her next appearance date before Judge Webster on Monday, August 11, 2025 at 9 a.m. Any other matters to come before the court, Mr. Sweeney?
No, Your Honor.
And Miss Leslie?
Your Honor, my jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas Rule of Civil Procedure. I appear specially, not generally, and have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognizing Kansas jurisprudence. Second, I challenge subject matter jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212, B1. No verified complainant from any injured party has been filed as required by KSA subsection 22-2301 in Butler County Local Rule 3.1. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudential principles adopted by Kansas courts in State ex rel. Morrison versus Libius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my conveyance and was exercising my unalienable right to travel, placing it outside the territorial jurisdiction of traffic enforcement under KSA subsection 8-244, which by its plain language applies only to licensees who have voluntarily entered the regulatory framework. Fourth, the prosecution cannot establish the corpus delicti of the alleged offenses. As held by the Kansas Supreme Court in State v. Stern in 2015, the corpus delicti rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of officer's lawful execution of duties. Where the initial detention was unlawful, as it was here due to lack of probable cause, there can be no derivative crime or of interference. Fifth, the refusal to provide identification is not a crime in Kansas, absent specific statutory circumstances not present here today. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a person solely to obtain identification violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas courts. In one moment, please, while I gather another statement. Okay, and another thing is, and this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically, this court referred to me by the term sovereign citizen, pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The use of that term demonstrates either a prejudiced bias or a judicial predeposition toward delegating the substance of my legal posture. As the Kansas Supreme Court was held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice in open court. Wherefore, I respectfully move this honorable court to dismiss all charges with prejudice for lack of jurisdiction, issue a finding that the prosecution has failed to meet its burden of establishing jurisdiction, order the immediate return of all my property seized, including the 251 USD, confiscated and converted to a reloadable Visa card without my consent, order the expungement and permanent sealing of every associated record pursuant to KSA subsection 22-2410, award compensation for the full measure of damages sustained, including costs for my automobile window repair, bail costs, and compensation for unlawful detention and deprivation of liberty, grant such and other and further relief as this court deems just and proper. The breaking of my automobile window without warrant or probable cause of a search and confiscation of my currency constitutes violations of clearly established rights for which the law provides remedies pursuant to the maxim ubi jus ibi ridiem, where there is a right, there is a remedy. I reserve all rights without prejudice, waive none, and maintain my special appearance for the sole purpose of challenging jurisdiction and preserving my alienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And thank you for hearing me. I do appreciate you, Your Honor, and thank you for your time.
And once again, matter is set before Judge Webster on Monday, August 11, 2025, 9 a.m. by Zoom. There being nothing further to come before the court is in recess, and have a good day, Miss Leslie.
Thank you, Your Honor.
Need to be taken or should be called?
Your Honor, while I would hardly presume to lecture the court on appropriate order to conduct business, there does appear to be a number of attorneys, including the county counselor, on the Sidney Leslie matter. State has no objection taking that up first if the court so wishes.
Okay, and we have Attorney Peterson here, yes?
Yes, Your Honor.
Okay, we are on the record in BU 2025 CR 250, State of Kansas versus Sidney Taylor Leslie. Please announce appearances.
Jared McGeer on behalf of the state.
Sidney Leslie.
Sidney Leslie appears on Zoom, and with Counsel William Peterson also on Zoom.
Very well.
Your Honor, if I may, Terry Hulskamp, appearing Butler County Counselor on behalf of the Butler County Sheriff's Department.
All right. And at this time, I show that we're on for bench trial. Is that what you're showing, Mr. Regier?
That is the state's understanding, Your Honor.
And are you ready to present your evidence?
The state is so prepared, Your Honor. The state understands there are a number of witnesses present who have honored their subpoenas.
Yes. Now, there was filed yesterday a motion for continuance. Does anyone wish to be heard on that motion?
I do, Your Honor.
Go ahead, Mr. Peterson.
Thank you, Your Honor. Ms. Leslie recently retained me to represent her, and when I say recently, that was just over the weekend, and I entered my appearance on Monday the 27th. As the court may see, Ms. Leslie filed several pro se motions trying to wade through this case on her own, and then has now sought the assistance of counsel. We can discuss the other motions later or at another date, but being recently retained in this matter, not having the opportunity to review full discovery and further advise Ms. Leslie on options in this case, I would ask to continue this to another docket date or however Your Honor poses these settings for a bench trial down the road. And I did speak to Mr. Regier about this yesterday. I don't believe he has an objection under those circumstances.
Mr. Regier, it looks like the motion to continue was filed yesterday. Do you have an objection to continuing it? As you noted, there are a number of state's witnesses here.
Your Honor, on the limited issue of continuance, the state has no objection to resetting this matter. As of, within the last 24 hours, I have had the opportunity to communicate briefly with counsel for the defense regarding this matter. However, there is also a file on behalf of the county counselor. I'm not sure if Mr. Huelskamp, filed by the county council on behalf of the sheriff's office. I'm not sure if Mr. Huelskamp wishes to be heard on that issue or not.
Well, I see that Mr. Peterson has the motion to continue, and then his client, give me just a moment here. Mr. Huelskamp, do you want to be heard at this time?
Your Honor, I don't know if this is actually on for hearing today on my motion to quash the subpoena ducus tecum that was filed. I don't even know if Mr. Peterson is aware of it. But I did file a written objection to defendant subpoena ducus tecum and a motion to quash on August 28th of 2025. I did not set an initial hearing on it, so I'm not real sure whether or not this is the hearing date. I was just advised to be on the Zoom today.
All right. Well, we have the request for discovery, and Mr. Peterson, was that the one that you referenced filed pro se by your client?
Yes, Your Honor. And I did see the motion to quash, and in some discussion with my client regarding that motion, if I have a little bit more time with her, there's a possibility that could be withdrawn, because I believe it has to do just with discovery. And again, I don't anticipate any issues in receiving that. And then if that's the case, we can withdraw that motion. I'm not prepared to do that right now, but yeah, I would certainly, and I had a little bit more time, could have possibly done that before Mr. Huelskamp had to appear, but I believe we can possibly get in and resolve that.
All right. So that is her pro se motion before you entered. And it is in response to that the Mr. Huelskamp, your motion to quash was filed. Is that correct?
It was with respect to the filing of the subpoena ducus tecum and the actual service of that on the sheriff's department.
Okay. So if Mr. Peterson meets with his client and withdraws that, that would take care of your concerns, Mr. Huelskamp?
Yes, and in the interim, just so we don't have to produce any documents.
Okay. Mr. Regier, your response to all of this, your position again?
Again, Your Honor, on the limited issue of continuance, the state does not have an objection. I would also tell the court that it is the state's understanding that discovery has already been provided in this matter prior to counsel for the defense entering his appearance at least 1 week prior.
All right. Well, I am going to continue this to let the counsel try to, now that Mr. Peterson's on board, let him counsel his client on what's admissible and what isn't, and to try to see if there's any resolution on this matter short of trial. If there's not, trial is not a problem, of course. But I don't see how we can have a trial till we resolve some of these motions that are pending. So I will continue this. The time will count against the defendant, though. Any objection to that, Mr. Peterson?
No, Your Honor. No.
And how much time do the parties recommend that I set this over? How many weeks?
My suggestion would be 30 days to 6 weeks, if that's acceptable.
Mr. Regier, any objection to 30 days to 6 months to set this over?
2 weeks.
Your Honor, the state would object to a 6-month continuance.
6
As
weeks.
to a more timely continuance date, the state would not oppose such a date.
All right. So Destiny, 30 days to 6 weeks. What would we have? In other words, 4 to 6 weeks.
Your Honor, I have December 31st at 1:30.
How about New Year's Eve? Anybody want to do this New Year's Eve?
I actually, one other question, Your Honor. In this trial setting, is Zoom the only option for that, or is an in-person setting something we can request?
Well, that's typically the way we do it. Are you thinking that you need an in-person or want an in-person for some reason?
Want would be the appropriate verb there. If Ms. Leslie lives in Wichita, I'm in Topeka, we'd have to travel. Obviously, for a trial setting, we were going to be in the same room. And again, just in taking testimony, it's my strong preference that's done in person. But obviously, I don't have anything that I can think of right now that necessitates,
Okay.
possible. Well, and I say that obviously, if the video needs to be shown, those technical difficulties can sometimes get in the way. But it's just one of those I prefer to have those. I know I can do that in person. Then again, videos can be shown on Zoom, but again, it is a preference. But again, when we're providing testimony from several different witnesses, and they're all there in Butler County.
All right. Do we have that in person at that time? Do we have a courtroom available for in-person, Destiny, or do you know?
That I'm not sure. I can double check with Michelle, but I know that a lot of the in-persons is just with the court security.
Well, I think we can probably work that out, especially on December 31st. It's probably going to be kind of scarce around the courthouse anyway. Mr. Regier, do you have a position on whether it's live or Zoom? Well, it's going to be live, whether it's on Zoom or in person. Do you have a preference to in person?
No preference per se, Your Honor, although the state's understanding is that the court has traditionally set these bench trials by Zoom fashion for various reasons. As to whether or not that applies in all cases pursuant to administrative order, I would need to research further before I can advise the court as to that.
Well, I know with police officers or sheriff's deputies, many times they're on duty and they're able to appear by Zoom without as much disruption to their duties, especially if they're on patrol. Mr. Hulskamp, do you know if there's any preference from your deputies, the sheriff?
No preference, Your Honor.
Okay. Anything else we need to address?
Your Honor, does the court, or with the state's information, does the court intend to address the outstanding motions in this matter at the next setting?
I think it would make more sense. Do you want to do them next time, Mr. Peterson, or today?
I think next time would be appropriate.
You want to take them up the day of trial?
Yes, I anticipate providing further explanation, or as I said, possibly withdrawal of some, depending on the circumstances. So,
all right. Okay. Well, then that will conclude the Sidney Taylor Leslie matter for today. It is continued at the defendant's request to December 31st at 1:30 by Zoom. And the defendant will be continued on the cash bond that she posted May 21st to 25, with the added conditions that she reappear by Zoom with counsel December 31st at 1:30. If there's nothing further, we are in recess on this matter, and everyone on this case alone is excused. But if you are here on one of the other cases, you will have to stay.
she's on.
Record in BU 2025 CR 250, State of Kansas versus Sidney Taylor Leslie. Please announce appearances.
Jeremy McGee on behalf of the state.
Sidney Leslie appears on Zoom, and by counsel William Peterson, also on Zoom.
Mr. Peterson, we are set for jury trial this week. How does your client wish to proceed?
Your Honor, my client is still requesting to have a jury trial. There are a couple of motions that have been filed. One from the defense, the compelled discovery, which I think Mr. Regier has resolved in his response. But the state filed the motion in limine this morning that I did by chance happen to see and have reviewed, but it requires a response.
All right, so these are separate new issues that have come up since some of those past hearings we've had.
Yeah, yes, certainly like I said, the discovery one, Mr. Regier responded to that and indicating that the documents that we were requesting, use of force reports, did not exist. And if they don't, then that obviously issue on that discovery would be moot.
June 12th of 2026, defendant's motion to compel discovery, I see. There's a Giglio issue, is that right? Or somebody thinks there is anyway.
That would have been our argument, Your Honor. And again, to these documents that are referred to as use of force reports. And again, in Mr. Regier's response, he said that the sheriff's office indicates they do not exist. So they don't exist.
Set a hearing?
Pardon?
We need to set a hearing for that, or?
Not for that. I would be comfortable with Mr. Regier acknowledging that on the record, and that again would be resolved. However, the state's motion filed this morning, or motion in limine, I think does require a hearing.
All right, Mr. Regier, you don't think we have a Giglio matter or any use of discovery that needs to be reported?
Your Honor, the state had addressed those matters in its response that was filed with the court previously, and the state does stand by its response, addressing all issues alleged issues raised by the defendant in their motion that was filed approximately a week and a half prior.
All right, now then, today you filed, Mr. Regier, a motion in limine, is that right?
That would be the state's understanding, Your Honor.
You want to limit evidence in jury trial, barring irrelevant and potentially prejudicial material of any testimony or questions pertaining to the sovereign citizen movement, sovereign citizenship theories, or others analogous of the same. Is that right?
That would be the substance of the motion in limine, Your Honor.
And you feel that there's a possibility that that could come out if I don't make a motion, or if I don't grant this motion?
That would be the state's position at this time, Your Honor.
And that if it does come out, it would be prejudicial to the state?
Your Honor, in the motion limine, the state's position is that they would be prejudicial insofar as that they would prejudice the jury, which is the second prong of the state be quick factor insofar as making such an order necessary.
So where would these comments come from? They would come from the defendant?
That would be the state's understanding, Your Honor.
And if you would proffer, what evidence makes you think that this evidence would come out without a motion?
Your Honor, the state would proffer that in multiple hearings previously, such theories have been advanced by the defendant on multiple occasions. There also appear to be a number of filings in this matter which would reflect such, I guess, pseudo theories, for lack of a better term, and the state would have concerns insofar as ensuring a fair trial on both sides.
When these came out previously, was Mr. Peterson on board as counsel, or were these by the defendant pro se, if you recall?
Your Honor, it would appear that the bulk of such statements were advanced while the defendant was operating in a pro se fashion.
Mr. Peterson, I don't want you to have to give away anything that you don't have to, but do you need some time to respond to this motion? Did you tell me a while ago?
I think it does require a response. Again, just from what Mr. Regier said there, I'm not sure what he's asking to. I mean, if he's saying sovereign defense will not be put forward, that's not a problem. That's not what's happening. But that the officers used that language, not my client, in this encounter.
Oh, okay. All right, so we may have to have a hearing on that, we may not, but you certainly have a right to respond. This is, the state has a right to pursue its motion. So I don't know yet. You're still wanting a jury trial, correct, Mr. Peterson?
Yes, Your Honor.
All right, I'm gonna have to put this at the end of the docket too and sort out if we need to make that decision sooner or later. If it's not going, we can make it later, but if it is in time, we'll need to take care of that prior to Wednesday.
I understand.
So you can either stick around with your video off or audio off, or you can have us contact you at the end of this lengthy docket, whichever one.
I'm good for a couple hours, Your Honor, but so yeah, we'll stick around.
Well, if I can't find any of you that are waiting till the end, I'll contact you because I'll know you had to go. All right, thank you.
Thank you, Your Honor.
And Mr. Peterson, what did you tell me about Sidney Leslie again, if you did?
Well, Your Honor, the state filed a motion in limine that needs to be
Oh, yeah.
probably have a hearing, and that was filed this morning. So I don't know if the state's asking for time or what exactly.
Well, it seems to me, Mr. Regier, that might need to be set over so we can work on that one a little more. Are we okay? Anybody see a speedy trial problem? Defense probably not gonna tell me if they do, but
Your Honor, the state's information is that this matter previously first came before the court for first appearance before District Judge Hart on June 6th of 2025, and the matter was continued to August 11th. That would appear to be approximately 66 days. In the end, from the August 11th saying it looks like it was continued at the defense request, and to a bench trial saying October 29th, where it was again where the court made a ruling at the time for another continuance to a December 31st bench trial saying was to be assessed against the defense. Again, where it was continued again at the request of the defense to March 16th, at which time the counsel for the defense appears to have requested this case be set for jury trial, and the court did continue this at the defense request to a pretrial setting. So here we are.
okay, that's the one I did the pretrial on. One of them I did pretrial. Another pretrial?
Your Honor, this would appear to
Okay.
be the first time that this matter has come before the court for a pretrial.
Well, let's look at Sidney Leslie. What we're gonna do with those motions in limine. Mr. Regier, you filed the motion this morning, is that right?
That is correct, Your Honor.
And Mr. Peterson, your response to that is you need a little bit of time to respond to it?
Yes, Your Honor.
And that's the one about the sovereign citizen information, whether to keep it in or kick it out. And where's the defendant on that? Sidney Leslie is right there. I see her. Okay.
Here.
Mhm. All right. Well, I think we're going to have to. Missy, are you on here? Oh, you are. Missy, when can we set that motion in limine for hearing?
For which case?
It's Sidney Leslie, BU 2025 CR 2.
You'll need to ask Jennifer on that one.
Oh, that is BU. I'm sorry. I don't know why I thought that was yours. Jennifer, when can you give me a hearing date for that motion in limine? Maybe on a Wednesday afternoon at 1:30,
You want it on a bench trial?
if we can.
That would be July 8th at 1:30.
July 8th at 1:30. That work for both counsel? We'll have an evidentiary hearing if we need it.
Yes, Your Honor. And is that in person or
That's
Okay.
Zoom.
Zoom? And that is set for an evidentiary hearing if needed.
Yes, if need be, yes.
Okay.
We'll set that on my 1:30 docket. That's Mr. Peterson. That is my traffic docket where I actually take trials, but that's about the only place I can stick motion, so I put a motion hearing on there every now and then too. Of course, if you folks come to any kind of agreement between now and then, that'd be great. If you can't, I understand. All right. Miss Leslie and anyone here on that case alone is excused at this time. Does that finally let you go, Mr. Peterson?
And the jury trial has been continued,
It is
obviously.
being continued.
Okay. Thank you, Your Honor.
Yes, thank you. Clerk, please note that's being continued. All right.